This material is made available to you by or on behalf of the University of Melbourne under Section 113P of the Copyright Act 1968. It may be subject to copyright. For more information, visit the University Copyright website.
Up now about assignment 2, and you can speak more about that with your tutors as you move through that process. I might send more detailed information by that, but the subject guide has the key things you'd want to look at for assignment 2. Obviously, I've posted information on the LMS if you've had a look. Hopefully your download speeds are sufficient. I know sometimes if you don't have the best download, it can take a little bit of time because they're large drawing files. Well, they're in PDF, but they are large drawings. One key thing I would really like to reiterate at this moment is that please do not get in touch with the applicants, the council, the consultants, the architects, etc., because it will kind of drive them a bit mad. No disrespect to you, but I sort of run these things on good faith that people don't kind of hassle or bother or use the time of council or others. So please don't get in touch with them. There's all the information you need is available as you have it. So if you really do get stuck, speak to your tutors or to me to work that out. The other thing I'd like to stress is personal safety. You'll be moving around streets, and I know you can all do that, but since it's a university activity, I would urge you to just be careful to not go to visit any site really, but not to visit this site at unusual times of day where you might need to be concerned for your personal safety. You should do it at any time, I suppose. Probably go with a friend or two anyway to keep it interesting and fun. Be aware that you are allowed to take photographs when you're in the public realm, as in streets, but if someone gets upset or whatever, just apologise and move away. You don't need to make a point about that. It's very unusual that anyone gets bothered, but just be aware, what you probably wouldn't want to do is lean over someone's fence and take photographs, because they may well take offence to that. So use your common sense, I suppose, is what I'm really talking about. And if people ask you what you're doing, just say, I'm just looking at this site, I'm an urban planning student. And I assume they'll be fine. And as I say, if not, just apologise and move away. Don't get into a weird situation. I think it's only ever happened once in all the time I have given this lecture series, but I just want you to think about that. So at this sort of early stage, does everyone have a sense of what they're going towards with assignment 2? It's in the subject guide, there's information on the LMS. So maybe if you really get stuck, come back next week with some direct questions and I'll make time for that. Okay, so VCAT appeals. You will recall, I hope, from a couple of weeks ago that Lecture 6 talked about how it is that we get to VCAT from mainly the permit process, the application for permit process as set out in VCAT, in the Planning and Environment Act, I should say. So what we're going to look at today is this question of what generally is VCAT, their role, how do you get there in more detail, and in particular, we will be looking at bits of the Act that take you there, and when you're there, what happens in those processes. So the first thing is that it actually exists in its own right as an Act. So I'd recommend to you to have a look at the VCAT Act. Why don't we get it up and running right now? And just remembering, I hope that you're starting to use this website, Austlii. We go through into Victoria. There's a new format if you choose to use that as well. And if we go into Victorian Current Acts, we go to V for the, now here's where I wish I'd worn the other glasses. Victorian Civil and Administrative Tribunal Act, there it is. And we can start looking through that. Okay, so it's got a very similar kind of format, and over the last sort of 3 decades there's been a strong attempt to provide some similarity in the formatting of acts. Some of the very old ones, there aren't many left around, have a more difficult to navigate structure. But you'll see here if you go into, say, establishment of tribunal, here's how it is formed, and we've got these a president, vice president, deputy, senior and ordinary members, and the registrars. So it goes through all of the basic steps you would exist, so all of the fundamentals of its head of power are established in advance. And if you just look across it broadly, we've got a description of the tribunal in its general sense, its jurisdiction and its functions, and then general procedures. And then appeals from the tribunal. We go and have a look in there. And you'll see it's a reference to the Supreme Court. So we'll talk a bit more about that in a while. And miscellaneous. So one of the things I hope you would learn in this subject is this ability to go and get the fundamentals of a completely different act. You know, it might be environmental protection or so on and so forth, and to use it in some sense to do what you need to do. Obviously in urban planning we tend to deal most with the Planning and Environment Act. You'll see that VCAT has only existed since 1998. That's because prior to that it was called the Administrative Appeals Tribunal, and before that it was called the Planning Appeals Board, and before that the Town Planning Appeals Board, I think, or PAB, Planning Appeals Board, and so on and so forth. It's evolved over time to keep up with current expectations, and I suppose a tendency to push together functions to achieve efficiencies in government and administration over time. So it's what we might call here a super tribunal, and I'll talk about what that means in a moment. But its purposes are very important to consider. Purpose is to achieve expeditious, as in meaning as quickly as is appropriate, and cost-effective resolution of those disputes which are now committed to VCAT for determination, and also to exclude frivolous and unnecessary appeals, as in we're going to try and exclude things that are a waste of time and that don't add to the process. Now there are some tensions in that. The other thing I'd like to just put to you right now is, who knows what this is here, this thing I've partly highlighted? Case law, bang on. So this is a reference to a particular case, and I'll do it now with everyone here, just so we've gone through it. So if we open up a new tab, I've got the worst mouse on the planet. I'll open up another Austlii so I can leave the other one running. And if we go here back to Victoria, and if we look at Victorian Civil and Administrative Tribunal from 1998, and you can see there's a whole lot of other tribunals that have operated at various times as well. And if we go into there, we can find, hopefully, where's the search function gone? Oh, they've changed it on me. Can anyone see, because I'm a bit blind, where the search function of that has gone? Oh, I see. We need to go into the planning one. Okay, well, this is, I was going to do this a different way, but I normally just go straight into planning. So we've got, what we've got here is Victorian Civil and Administrative Tribunal, and this is a database that has all of the decisions with reasons and other information in there. But one of the things about the tribunal is that it has a whole bunch of other functions aside from urban planning. So this is worth knowing because they have somewhat different processes and different regulations associated with them according to the nature of the proceedings that usually occur. So if we look at the planning and environment list, hopefully you can start to see cases, and I don't know quite why they're arranged like that, but we can then go in and we can search for stuff in there, and you can see that one there is the case, and you can see that there was an issue there, and this is something I'd like you all to become very good at reading and understanding what these cases mean and how they're valuable and what their purposes are. It's not just to resolve a dispute, but to establish a body of understanding and practice that means we build knowledge over time and provide guidance into the future, as well as just making decisions. So I won't go through that in great detail, but there are questions here about costs and being frivolous and all that sort of stuff, if you want to have a look at that one on your own. Fairly short one, just a few lines. Okay, so this is about the whole VCAT list, not just the planning list, I might add. Okay, so the other thing that the tribunal is meant to do is objective, prompt, efficient and ineffective distribution, and you can go in and look at those tribunal hearings to understand how they're applying those purposes. So I showed you the big long list in the database previously, but generally speaking there are civil matters, administration matters and human rights, and you can see that planning is underneath the administrative set of functions there. So the tribunal has a few key characteristics you should be aware of. One of them is that it's not a court of law. So in a court of law, there are much stricter procedures and processes in place, and costs are often awarded, penalties, cross-examination by barristers or etc., lawyers, and generally speaking, they find out who is to blame or who should be punished or how monies are restitution occurs or fines are paid, all of these sorts of things. The tribunal is not oriented towards those things so much, but rather to try and make a decision that is a useful decision. And those decisions in the planning list are oriented largely to the purposes of the Planning and Environment Act. So the reason there are different planning lists is so the different tribunals work in conjunction with the different acts by which someone might get to the tribunal. So if it's a planning matter, the tribunal is trying to extend the purposes of the Planning and Environment Act, and so forth. rather than have a completely different way of thinking. So there's no rules of evidence or of procedure with the same rigour that occurs in a legal court. So if someone comes in with slightly dodgy information, then it's not that they'd get away with it, but it's not treated as a criminal matter in the same way. But there are other ways of dealing with that. For example, someone who provides expert evidence, if they come up with slightly dodgy or wrong information, they will lose their standing and they won't be able to act as an expert witness anymore. So there's some tensions in that, I suppose, because people might try and influence things a little bit. On the other hand, the tribunal kind of expects that and makes its own decision anyway. So the tribunal can set out what they think is the best process to resolve a dispute. So they don't have to follow exactly the same way of doing things every single time. The real thing they're trying to do is get all the information that they need and let everyone have a say, procedural fairness, in the way that might be most efficient and bring all the information out to actually be able to make a decision. And in the VCAT Act I just showed you, that's the framework by which it exists. And one of the characteristics of VCAT is that its jurisdictional power to do things comes from the Act, in this case an Enabling Act in the Planning and Environment Act 1987, as adjusted. The powers that it's exercising are coming out of this Act as we move forward. So this is important because VCAT's exercise of powers when it's working in the planning list revolve around the powers it has derived from the Planning and Environment Act. I'm sort of trying to say that in a different way. So if something is prohibited altogether by the planning scheme, and the planning scheme has power by this Act, the tribunal is bound in the same way as anyone would be that that thing that is prohibited remains prohibited. So this is a way of trying to join together all of the different decision making so that VCAT is not inconsistent with the other acts from which it derives its powers and responsibilities. Does that make sense? I hope I'm getting a couple of nods there. Yeah, okay. So, of course, it has decision-making powers that have some differences, but largely the way it uses its discretion and its decision-making relates directly to the Planning and Environment Act. Okay. So, one of the things about the VCAT Act is that it directly looks at and proscribes, proscribe meaning excludes, other courts' ability to make decisions. So this in some ways protects VCAT and enables it to make its decisions without the expectation that there will be this regular imposition of a legal court's powers over VCAT. So in some other jurisdictions, legal courts will come in and they'll say, that's wrong, we're going to make a decision on top of it, we're going to make a decision on top of it. That only happens in extremely limited cases in the planning list, and the main reason for that is that most of the decisions in VCAT are administrative and include discretionary understandings. And it's simply to also make things more efficient over time. So we don't have this endless litigation and court proceedings as we move forward. So if the tribunal has jurisdiction, then it runs its procedures without too much fear that there's going to be another court that takes over. Oops, that mouse is driving me a bit mad. Sorry. If there are particular cases under section 52(1), where if it were to be held in a court for some reason, and let's look at section 52(1), and you can start to think about why. So if we go down to section 52(1), so limitation of court's jurisdiction in planning matters, and you'll see the words right there. The Supreme Court, County Court, does not have jurisdiction to hear any proceeding under a planning enactment. And basically that's saying if the tribunal can do it, let it do it. And I guess you can see these rules being the product of many years of very tangled decision making, and it's a way to try and resolve that and to make things a bit quicker and cheaper, even though VCAT is kind of expensive. However, if the Supreme Court, the County Court, the Magistrates Court is of the opinion there are special circumstances, the court may direct that to occur. That is an incredibly rare thing. It's very unusual in the Victorian system. There are some circumstances where there might be a criminal proceeding happening in parallel, but as I said, they're pretty rare. So I'm sort of slightly slavishly going through the Act because this is a core skill that you need to develop and to think about, and it's not just the VCAT Act, but probably mainly the Planning Act, to think about that. And I won't go through it right now, but to think about how that discretion would be exercised by another court. You can go and have a look at this case, which explains the circumstances by which they would see it as appropriate to take over or not the VCAT's powers in that case. Okay, so VCAT, if you break it down, is really doing one of two things at any time when it's relating to the planning and environment list. Most of the time, it's undertaking a review jurisdiction. And we use the word review quite carefully because it means reviewing someone else's decision. And that will be in one of two roles, and you can probably guess these: the responsible authority role or the planning authority role, the way they made a decision. Or sometimes it might be making a proceeding in the original jurisdiction, as in no one's made a decision, but there's possibly a good example would be a defect in procedure, and the VCAT is going to make a decision about whether or not they followed the processes of the Act. So if someone did something that was prohibited and it needs to be stopped, or if there's a need for a direction by the VCAT, as in there's uncertainty about what to do because maybe we can't decide if it's considered a tavern or a nightclub, which one is it? And then you can seek that the VCAT will provide direction on what to do. So that would be in an original jurisdiction, for example. So most of the time it's working as a review jurisdiction, and most of the time it is a merits review. So you can see there often it's a council being a responsible authority. Oh, that's actually review of the decision of whoever. Yeah. It's a slight typo there, sorry about that. And one of the key phrases you might want to think about using here is the idea that the tribunal, VCAT, stands in the shoes of the original decision maker. So where the responsible authority, as set out in the Act, so that's the City of Melbourne or the City of Yarra or whoever, make a decision, when it goes to the tribunal becomes the responsible authority when that process is invoked. An important principle because it gives you an idea of what the scope of that decision might be. Effectively, they have pretty much the same powers as the responsible authority as set out in the Act. So that, again, is an indication of the extent to which they can exercise their powers and for what purposes they might be, and where the decision criteria for their exercise of powers would lie. So you can see from these initial comments on VCAT that it's not meant to really provide a different way of thinking. It's a review of the application of the planning scheme, effectively, and of the processes set out in the Act. Who knows what de novo means? They're trying to slowly remove the Latin legalese out of the courts, but this one still exists. De novo. I saw your lips move. Afresh, yeah, and what does that mean?
So they're giving all the information from the original party instead of going to the third party?
Close. Basically, they're making a new decision. So, yes, they get all that information, but then they decide, well, we are now the decision maker, and we'll make a new decision. And however it went before, who was right, who was wrong, not really that worried about it. We're going to make our own original new decision. And it can, and well, it should, actually include the whole decision. So if they notice something that is not correct in the previous decision, and it wasn't even the reason we're at the tribunal anymore, they can still make a decision about that. And the reason for that is that we want good decisions, and if we've got all this energy going towards it, if they pick up that some of the conditions didn't make sense, or the drawings had a problem, or it didn't take into account state planning policy, they will make a decision of their own. Ma'am?
Does that mean they can request further information?
No, it doesn't usually. However, what the tribunal can do is, well, it depends how it got to the tribunal. Generally speaking, they'll use the hearing as a process of getting what they need to make a decision. If they look at it in advance and they would expect that new information would be there to help them make a decision, they might get in touch. That is fairly unusual in the tribunal space, but what can often happen if they felt there was a need for better information, they would request it during the hearing, or after the hearing finishes, they'll go off and make their deliberations, and they might make their own investigations. But essentially, the tribunal tries to limit how much new information comes, and I'll talk about that in a moment. Basically, if the tribunal is making decisions that don't help your case when you go, it's your fault. But so, usually people are paying a fair bit of attention to get everything there. I guess probably the main way new information comes is changing the drawings, which I'll talk about a little bit later. Okay, so this idea of de novo or afresh is really important, because if you go along with something a bit dodgy or something missing or whatever, the tribunal might say, I suppose potentially we can't make a decision on this because it doesn't make sense and we refuse it. So I guess beware if you're going to the tribunal. So you can probably see where I'm heading with this. Oh, I keep forgetting to maximise that. That VCAT's powers, since they're effectively coming from the Act and the planning scheme, those powers are relatively similar, or quite similar I would say, to the powers of any responsible authority, aren't they? So they can say, yes, the original decision was a good one, and we agree and we affirm it. And whatever that might be, it might be to say, to refuse, it might be to say, permit with conditions, or they might, and this is more common actually, might vary the decision. And they might vary it outright by saying, well, it was a refusal before, but we're going to say it's a permit now. Or they might change conditions on a permit. Those conditions can be small or they might be quite large. It's not unusual for very large towers, very large structures, if the tribunal perhaps is concerned about neighbourhood character or overshadowing or the quality of design, they might say, you know, removal of the top 2 stories, or to change the car parking entrance or the colour or whatever it's about. And so I guess this is the challenge of going into the tribunal, whatever role you're playing, that they have these de novo powers. They might make significant modifications. They might go in a very different direction, perhaps, to the way the responsible authority went. And generally speaking, people say VCAT's, people who use it a lot would say VCAT's relatively consistent in its views. But that's to say, when you get this grey area, you don't quite know what you're going to get unless it's clearly in or out. They might put aside the decision altogether and just make a new decision. So sometimes it might, the decision might have been made on neighbourhood character grounds, but then when you get in to the tribunal might say, oh, I don't think the neighbourhood character is such a big issue, but we're going to have a look at the car parking access and the overshadowing, and actually we're going to refuse it on that basis because they've got this power of de novo decision making. And they might just set aside the decision and say, there's no need for us to make a decision here. You go back and make that decision yourself. And that's remitting, is giving something back. I would say that that is relatively unusual and would really just be to make a point. But you can see the final red dot point there. A decision of the tribunal is deemed to be a decision by the decision maker, as in the responsible authority or the planning authority in their original role. So the output of the tribunal is a direction. And if you read some cases, you'll see that they will give an order. And that order goes back to the responsible authority or the planning authority to do something. Generally speaking, it's the responsible authority because it's usually about permit processes, most of the stuff we do in urban planning. So they essentially, it's probably written slightly cryptically here, but the tribunal might say, yes, we think a permit should be granted with these conditions. They'll write those down, and then at the very end it will order the responsible authority to issue that permit. So it goes back to the responsible authority, and they have 3 working days after the first meeting of that responsible authority after it receives a copy of the order. So when they say order, they really mean it. When they say the first ordinary meeting, it's a meeting of council as set out under the Local Government Act. And essentially this means that council, they might have their nose out of joint, they might be very upset about a decision of the tribunal, but they can't get out of it. It must be done expeditiously. Sometimes there is a need to amend or cancel permits. What might be an example of a need to amend or cancel a permit, do you think? And why would VCAT be involved? It's kind of written up there. I mean, one example might be that the drawings that were submitted had some gross errors in them, or even minor errors, but they might have some implications on whether or not it would impinge on others or cause problems. It might even cause a structural problem, or it might bring about overshadowing onto someone's garden that wasn't expected because they were drawn incorrectly. Also, it is not uncommon that when you start to go from the planning permit process, where you don't necessarily go into huge amounts of detail about the structure and actual building processes of a building or whatever it is, but then when you get down to brass tacks of actually thinking about the costings and the structural integrity, I say, you know what, it just doesn't work like that. I need to shift it around so I can put some reinforcement there or whatever, and there might be a need just to change things up. And generally speaking, there is an amount of flexibility in the VCAT process without going right back to the very start of a planning application if it's not having implications for others. And so if VCAT has issued a permit, then VCAT is the body which would allow variance to that permit, or they would consider modifying that permit. So examples might be realigning a car park entrance, or modifying where windows are because the internal arrangements didn't quite work, or changing a roof slope because it wasn't going to drain properly. All the kinds of things that might come out through the building and design process. Or it could be a market process where the original application might have had 100 one-bedroom apartments in it, and then the marketing process revealed that they needed a different mix. And if it didn't have implications for car parking or other things, then those internal drawings could be modified, potentially through an amendment to the permit. So, can I give you some homework, he says, deciding to do it. The Wade case would be an excellent thing to look up. And I say excellent because it's the kind of thing I would put in an exam. And to think about what those implications would be when we have certain need to fix errors or processes, or the sort of things that the VCAT would look at. Okay, let's have a little pause because I can see your energy's flagging and we're about halfway through as well. So I hope to finish a little bit earlier tonight to let you all have a gather breath. So, short break, 5 or 6 minutes past 6 o'clock, and we'll finish the next half. I know it's a bit dry tonight, I'll spice it up with more illustrations and drawings next week. Okay. So we just talked about this amendment of permits power that can be used, and I encouraged you to look at the Wade case as something to study, and you can find a number of different references to the Wade case. I'm pretty sure that Stephen Rowley has made some references to it in his book. You can also look in Eccles and Bryant, which was the book previous to Stephen's. Eccles and Bryant's, it's called Using Victoria's Planning System. And you can also check on Ostley, and you will find many references to other cases that use that core principle. So I'm kind of encouraging you to learn how to learn in the statutory planning way with this. Okay, so declarations I mentioned a little bit before. These can be very important, and a good example is the way that over time the definitions in the planning scheme at clause 72 might change their meaning in popular language. And usually that's not a big problem because the definition as it is written is understood, but often people might misuse that as a result. But probably the real challenge comes when the nature of business and the ways we do things with different technologies will change over time. So essentially the complexity of the planning scheme is sometimes its own worst enemy, because it's actually quite challenging to keep it up to date. So sometimes we need a direction to understand a complexity. So what I gave examples before. What is a nursery? Exactly what is a helipad or a heliport? Is it the bit you land on, or is it the surrounding buildings? So all of these little complexities that are not necessarily understood easily. It might be outlining a proper process. So if there's no real direction on it, there's not real clarity, do we need to apply for this new activity? Is a laser tag, is that sport, or is it a place of assembly? Now, I'm just sort of picking examples out of the blue that I've come across as questions. If you don't understand those things, you can seek a declaration from the tribunal to clarify, well, do I even need a permit in the first place? Before you go down a whole process where it might be wrong later on. So it's a way of clarifying things to be able to move forward. So it can kind of be about anything. It could be the right process. It could be to determine when is there a point at which commercial advantage is allowed or is necessary to take into account in a planning application. So generally speaking, the planning system is putting those aside, but when it gets to a certain scale, it kind of kicks into Section 4 of the Act, where actually it is part of, because it's such a big application, maybe we do take into account the economic prosperity of an area. Or is there a point when we do take into account the number of objections? So all of these sort of matters, if it can't be determined, we go to the tribunal and we seek a declaration so that that can be understood more fully. Sometimes VCAT needs to put a stop to something if it is going wrong and it needs urgent action. So there's a whole range of processes, and I won't go into these in full detail right now, but it is common it is sometimes necessary for VCAT to step in, for example, if someone is demolishing something without a permit, and you think, whoa, hang on, that's a heritage building, or it's got a heritage overlay, they haven't got a permit, we can't wait till next week or the week after or whatever, we need action right now. Or it could be the neighbours next door got a permit, but as far as I can tell, they're building it right next to my wall, and I'm pretty sure it says here it should be 5 metres set back. So I've got light coming in. So what do you do? And you know, they're starting to pour concrete and all kinds of stuff. You need action. So you would seek an enforcement order from the tribunal. Sometimes, as the last point there, there's the VCAT will compel someone to restore things if it's been done wrongly. There's an example very close to us here of the Corkman Hotel. Matt smiled at me as if he knew I was about to say that. We're all obsessed with it, I think. And a heritage pub that is next to the law building, and some developers thought, oh, we'll knock it down and build a big tower and we'll get away with it, we'll just pay the fines. But it's not as simple as that, because the tribunal or the minister taking over the planning powers can actually compel someone to restore it. So it's a complicated process, but it's to try and actually give the planning system enough powers to achieve its objectives. And then we've got merits cases. Well, that's just to say the powers or the responsibilities, the rights of people to actually by different parties. Did I skip a page there? Oh, okay. So one of the reasons to go to the tribunal is on a merits case, and some people have powers there to go who are not the applicant and not the responsible authority. They're the objectors as well. And so if you recall last week, I talked about how you can get to the tribunal. The applicant is sometimes one of those people, but also objectors may have rights to do that. So, if we start looking through those, it is appropriate to know, and these are under the Planning Act, that a range of different parties have powers and responsibilities and rights to appeal against different things. So, under Section 77, there can be an appeal against a refusal to grant a permit. Who would have that right to lodge that appeal? The applicant. Excellent. But you also have other appeal rights that relate to processes that are imposed upon you. So under Section 78, you can see there, you can have a review against a requirement by the RA to give notice under Section 52. Now, what was Section 52 saying? I thought you would know this off by heart now. Tattooed it onto your arms. Section 52? No, that's under, these are under the Planning Act. So if you go to Section 52, I won't do it. Let's have a look at it, guys. So, got Section 52, go back. So that's the VCAT Act. We'll go to the Planning and Environment Act. This is one you should really get straight and... Okay, here we go. Okay, notice of application. So, when there is the potential for material detriment, the responsible authority is compelled to give notice itself or require the applicant to give notice. And sometimes that might be quite an onerous thing and it might slow down the process, but probably mainly it gives people the potential to object, or many more people to object and get involved. So because these processes are here to try and make things fair and not to let any of these parties potentially do things wrong, or to be corrupt, or whatever it might be, or just be incompetent, there is a power, an appeal right under Section 78 of the Act that we say, well, we don't think we should give notice because it's so insubstantial. Now, you'd hope it wouldn't get to that, but the fact that the power is there means someone could say threaten, or just say, look, you know, the Act gives us that power. Does that make sense? So if we go to Section 78, it might make it a bit clearer. Oh, 77, sorry, wrong click. So in this part of the Act, this is the Planning and Environment Act, there are all these potentials for people to appeal against things. So it tells us who it is who has that power. An applicant for a permit may apply to the tribunal for a requirement by the RA to give notice under Section 52. So Section 52 is the bit where they can say you must give notice. Section 78 is the bit where they say you've got the right to appeal against it, should you think it's necessary. And of course there's also there further information under 54. It's getting late in the day, isn't it? Okay, so it could be that you think that the responsible authority is unduly making it difficult for you as an applicant, requiring all this extra information, you know, a big study, a geotechnical report, an urban design report. You think, we don't have the money for this tiny little thing I'm changing my back windows for. Why would we need that? And if you feel it's necessary, you have that right to appeal against further information. So generally speaking, we don't need to impose or go down these paths, mainly because we have appeal rights in the process, and it keeps things kind of, it stops people doing things unduly, and it limits excessive powers. Most of the time we reach a happy medium between them. So, so they are both rights of permit applicants to give notice for further information under Section 54 of the Act, appeals against failure by the RA to grant a permit within the 60-day time limit. Okay, I talked about this a little bit last time. There's a 60-day time limit. So what's a failure to, what does that really mean? What's a failure to determine? Just as a little reinforcing exercise. They just haven't made a decision within this 60 days. So you get the 60 days. What takes away from the 60 days? What stops the clock? Request for further information under Section 54. Advertising or notification under Section 52 is excluded from the clock. Okay? So those provisions are there, so if people are slow, it doesn't then make it difficult for the responsible authority. It's their own problem, effectively. Okay, so that's the 60 days stopping the clock stuff. And generally speaking, the applicant doesn't immediately go and lodge an appeal if 60 days have passed. Because what it does, it takes them down the path of going to the tribunal, which might take them many, many more months. And in fact, it might put the responsible authority against them. If they just worked with them a little bit longer, they might get a favourable decision more quickly and without all that extra expense and without all the angst associated with it. But what it does mean, if they really drag it out, they do have a right of appeal. So it's, again, another little balancing act between bureaucracy and good decisions and costs and those sorts of things. Okay, so Section 80, appeals against conditions in a permit. I've talked a little bit about these things before. So conditions on a permit can have quite big implications. So it's not uncommon for conditions to change the floor space, the time limits under which you might be doing things in your permit, the colour, you know, whether or not you're allowed to clear the land, all of these sort of things. So if you feel that they're excessive or not appropriate, or that you just want to have a go because it might make you more money if you get rid of those conditions, there is an appeal right there as well. Oh, sorry, that mouse is driving me a bit mad. I should bring my own. And then rights under Section 81. Any person affected, generally the applicant or permit holder, for a decision not to extend time. Does anyone know what this extending time thing is? I understand you guys are going to look at a permit. You guys are going to show them a permit today, aren't you? So you're going to see a permit, just an example permit today in the tribunal. And on any permit, it has a time limit. And so it'll say, you know, the permit is issued to construct a 3-storey building. But every planning permit has a time limit on it. Usually there is a 2-year maximum period to commence construction and 2 years after the commencement of construction to complete it. Why do you think those conditions would be on it? Yeah, I think that's part of it, yeah. So people act on it, that's right.
The rules change over time, that's been on it 20 years or so.
That's right, I think that's taking it the next step. That if you get a permit under one set of circumstances in a place with a particular set of planning provisions, in 20 years that whole area might have transformed. There might be very different expectations for what that land might be used for. So if you had a permit for a factory, and it might even be noisy because people didn't care because it was largely an industrial area, in 20 years' time there might be very different environmental concerns, noise concerns. It might have been gentrified and there's a whole bunch of people living there because it was all rezoned. So in 20 years' time, you wouldn't want that permit to still have standing if it hadn't already been acted on. And so we call that a change of policy conditions. So what often happens, if you're an applicant, you get a permit and then you scurry away, you're a developer or whoever it is, and suddenly time's passing and you haven't raised the money for your project, or you just didn't get around to it, or whatever. You might come up and you think, wow, I can't start this project within 2 years. So you're allowed to request an extension of time from the RA or from the tribunal, according to who issued it. And they will basically use one test. Have circumstances changed, like the gentleman here described? And sometimes they'll say, no, you can't, we won't extend the time. And if you believe that that decision hasn't been made fairly, you're allowed to appeal it. So this is not a small matter, actually, because some large developments, you know, a massive tower block or a factory or whatever, might be worth hundreds of millions of dollars, and to not be able to extend your permit for another 6 months or whatever might be costing you huge amounts. So generally speaking, what applicants do, if it's possible, they just begin so that they don't lose that 2-year time limit. They just start demolishing and breaking the ground. But then they come up against the next thing, which is they've only got 2 years to complete the project after that. However, it's pretty difficult to say, don't finish your project because you've got a mess on your hands. So generally speaking, they do extend it, generally speaking, because it's quite hard to enforce. But yeah. So that's for extension of time and the ability to appeal that. So you'll have a look at a permit today and you'll see these typical components that make up a planning permit, and you'll see why what's written on there is actually super important. Almost every bit can have big implications. The other type of review, or what we generally call appeals in general parlance, is objector or third-party reviews. So if you're an objector, how do you become an objector? What's the thing you need to do? You have to lodge an objection. You made me think of something. So you've got to lodge an objection in writing in the first instance. Okay. So, so Section 52 requires notice of application, and all of those processes kick in. But in fact, people think incorrectly that you only have the notification time to lodge an objection for 2 weeks. In fact, you can lodge an objection at any time up until the decision of the responsible authority. I wouldn't leave it that late, purposefully, but if you're outside that time, you or your client or your friend or whoever can still put that in, and it could actually be really crucial to maintaining your right to lodge an appeal later. So generally speaking, in the Victorian planning system, if in doubt, lodge an objection early on, because you might then want to exercise under Section 82 of the Planning Act the ability to review a decision, to grant a permit, or in fact a notice of decision.
Would they ever look at they would look at you if it was just a frivolous objection in the first place, and in a sense seek for the fact that you wanted to get to the state? That would actually have no bearing on it.
Yeah, it's a good question. So normally they don't. But if you didn't follow through on your objection, you might, and particularly if a big developer is losing quite a bit of money potentially by a delay, and then you don't even turn up at the tribunal, they might consider doing it. It's become rarer over time because the initial cost of lodging the appeal is quite great. You know, no matter how rich you are, $1,000 or more is not a small amount when you think how much disposable income you have. It's not that much on the whole, unless you're super rich. So if it really was apparent you were doing it to be a pain, but all it really takes for an objector who's an appellant, if they turn up and make some sort of case that has some sort of value, they're not going to be considered to be frivolous and vexatious. There are a few people who have become serial sort of pests in the tribunal, and they start off gently saying, we're not going to let do, and eventually they'll take action. Because some people do love that whole opposing thing world. So that's a good question. If you're an objector, you maintain this right of review of decision in the tribunal. And anyone who has lodged the permit can do so. The objection can do so. And if you want to be joined as a party, Section 60 says that you can be joined to the appeal that is already running. So I mentioned this a little bit last time. If there was no appeal at all, you can't use section 60 to start the whole thing off if you've never lodged an objection. But if there is an appeal already running and there's some sort of point for you being there, like you're next door to a large development and it might have an impact on you, you could be joined. And VCAT generally takes the opinion that, well, if they've got something meaningful to say, we better hear it, just in case it influences our decision. But also to exercise natural justice, to try and let people have a go and get involved if it is reasonably possible. So if you want to look at the detail, you know, and I hope one of the things of this lecture has sort of brought out, if you're worried about any of the details of this, if you're worried about, you know, exactly what happens and can't happen, you go to that part of the Act and you look at it. If you're giving advice to a client or a member of the public or whatever you're doing, you simply go to the Act and read it yourself. And if it's still not sure, you know, maybe you have to get advice from a lawyer, or if you're a local authority and you can't decide, I suppose you would actually seek a direction if it's ambiguous. But mostly it's fairly clear what you do in these cases. Okay. So, Section 60 is discretionary, as in joining other parties to a hearing. And if you go and look in there, you know, if you are frivolous, etc., vexatious, you will see that Section 60 does exclude those people. And hence, VCAT is allowed to exercise its discretion. And if you want to have a look at a particular case about that, you can go and look that one up. Okay. So, if we then think about the actual proceedings at VCAT, we need to go and look at the VCAT Act. So when we're back here, you know, these rights here about getting to the tribunal, so to speak, these are in the Planning and Environment Act. But then once we start talking about the proceedings within VCAT, we're looking at the VCAT Act. So under Section 60 of the VCAT Act, there is the ability to exercise discretion about who can be joined to the appeal. And sometimes we might have people there, it could just be, well, if you just want to, we know that you don't really have a direct interest, but in the interests of openness and transparency, you could just be there to observe. Or you can be there to represent your friend or your neighbour or your client, but only in that way. Or you can come just for the one day. Or if you take instruction from the tribunal, whatever it might be. There are more detailed powers under the VCAT Act at Section 127. Sometimes they can even take people out if it is necessary. Generally speaking, however, it is normally the case that the tribunal wants to show that it is giving everyone a fair voice. And so I'm sort of harping on about this a little bit, but one of the real attempts, a really important thing of the tribunal and indeed of the Planning Environment Act is to not let there be any suspicion that people aren't getting a fair go under that core idea of the principles of natural justice. If you go looking in the under the VPP zones, some of the zones actually specifically exclude appeals. One of those, and I was thinking about this earlier, so it stuck in my mind, under the bushfire management overlay, there are no appeal processes under certain parts of that. Certain parts of the process don't allow appeals. And so it depends very much on the particular circumstance. We had very few of these provisions 20 years ago in the planning scheme, and as there was more emphasis on speeding up development and promoting large developments, there are more and more exemptions from review that you'll find in the zone and other provisions of the planning scheme. So one of the things you might need to think about as you work your way through the provisions that affect an individual site is you have to kind of think of the other things that might have implications for. Does this exclude objectors from having a say? Does it exclude people from having a right to appeal? Developers love those provisions because it means that they've got less people opposing them. Objectors hate them because it means that they're not formally part of the process. So it could be worth having a look through and thinking about the logic or otherwise of which zones and overlays and other provisions allow these appeal rights, and why would they do that? And is it really in accordance with the objectives of the Planning and Environment Act to exclude third-party appeals? I would mention at this point that many planning systems around the world don't even have appeals in the way that we do anyway. So it does seem brutal if you've had this expectation of always having a go, always being an objector, always being able to appeal. But on the other hand, the whole point of this Act is to try and promote development. So it sets up another tension. Okay, so there are many time limits and limitations on what people can do within certain times in the tribunal. Some of these stem from the Planning and Environment Act and some are from the VCAT Act. But generally speaking, I haven't shown you these, but the Act sets out the core processes, but there's also an associated set of regulations. And the regulations are less formal and more easily changed than the Act itself. So if you go into AustLII, you will see that there are regulations and different regulations for different lists. So if you find the planning list, you will see a lot of these things about time limits are set out in the regulations, like how long you've got to request further information, what stops the clock and all that kind of stuff exists within the detailed numbers of those exist within the regulations. So, if you want to review that you had to give notice, you've got 30 days to apply that, to apply for that appeal. If there's a request for further information, you've got 60 days. And so forth. I won't sort of go through them too slavishly, but review of refusal to grant a permit, you've got 60 days. If you're the applicant, I would point out. Review of failure to grant a permit, as in the 60 days not being met once you've taken out the advertising and further information. A review of conditions, you've got 60 days if you're the applicant. And a review of grant of permit, 21 days, obviously that's you being an objector to that. You've got 21 days to ask for a review. And an extension of time, you have 60 days. So, I mean, I'm starting to feel a little bit slavish going through them all, but you've got them all there. Another set of parties that can be part of this are referral authorities, and sometimes it's the case that there are rights to appeal a referral authority's condition, or a referral authority might even object to something. It could be that they're a water body that tries to maintain quality of water, or water flows or stop flooding. And it might not even be a referral authority, but it might say, well, I'm still worried that that change to the earthworks and the removal of vegetation might have implications for water flows and water quality downstream. We're going to object to it. So they also have the right to do that as well. So they have 21 days to request further information, and there are some tests there that can be applied as to the extent to which they can exercise those powers. One thing I wanted to point out here, if you see red dot in part of the title of some case law, that indicates that it's an important and very powerful precedent-setting determination of the tribunal. It goes back to the bad old days when in the tribunal, if something was changing the meaning of policy or reinforcing or set, a landmark decision, they would just stick a red dot on it, a little sticky dot. And if you were on one of the mailing lists, they would send it out to you with a red dot on it, just to let you know this is important, pay attention, because it's going to change the way in which decisions are made about this matter. So we've kept on with that, even though we're not sticking red dots on it. It actually says red dot on the title area of the appeal. And I'll get you to read some of those in the next few weeks. Referral authorities have particular powers there, and you can see, the kinds of typical things that they might want to say about an application that is referred to those. And indeed, if they haven't got enough time to make a decision, a very common thing is, say, a water authority might need to do some modelling or testing to work out whether or not there might be implications for flooding or water quality from a large application that includes earthworks. Just one example, it might take them a lot more than 28 days. They'll ask for an extension to the time that they have. And if there's no referral authority involved, of course, the RA can make their own decisions. Okay, so one thing, the referral authorities actually have very strong powers in Victoria, and surprisingly so, that if a responsible authority is issuing a permit or a notice of decision, they must include what the referral authority says it has to. This sounds like a very excessive power, but generally speaking, these referrals and the nature of those referrals is limited by the planning scheme, what it can make referrals about, what is being applied for and what is reasonable. But generally speaking, these are very routinised as well. I'll give you an example. Vic Roads has a long-standing policy that hopefully everyone knows about, that they are highly reluctant to modify entry and access points of major roads. So if they exercise that referral authority condition, it is very unusual that anyone is very surprised about that. Okay, so the last and short bit, sorry if I'm sort of charging through it all, is the review itself. So these were all, in a sense, how you get there and who's involved. Yes, ma'am?
Earlier when you talked about some reporting on coverage,
Yep.
we talked about VCAT's order and enforcement, and you gave
Yep.
example.
Yep.
Who takes that? That's not a coverage project, is it?
A number of, we'll go into quite a bit more detail in about 3 weeks. There are a number of different avenues to take enforcement action. It can be a member of the public. It can be someone who's, previously objected. It could be the VCAT itself. Yep, because... in that case, the minister used his powers to call it in that case. I understand. The responsible authority commenced that proceeding, I understand, and then the minister called it in because it was seen as of such significance for state policy, generally speaking, because this stuff is becoming more and more common. So I guess the minister thought, this will make me look good, but it's important. Yeah, so there's a number of different ways of getting to enforcement action. So how does a review occur? Someone lodges the form. Someone fills out the details, pays the money and puts it in. Obviously they need to be someone who has standing to do so, as in they've lodged the objection and there's nothing stopping them in the planning scheme. And then it kicks it into a number of steps. Those steps are set out in the Planning Act a bit, but mainly the VCAT Act in that case, because it kicks into becoming a VCAT process. And there's a number of practice notes associated with how processes are run in the VCAT planning list. It kicks in a bunch of steps. So one of them might be what we call service, where people are required to be given copies of information. So say I'm an objector and I'm objecting to a notice of decision. I'm required to serve that notice on the applicant who wanted to build something, the responsible authority, any referral authorities, the tribunal, and any other objectors. So it's kind of onerous to send all that stuff around. There's got to be a statement of grounds. This is very important because you need to say what it is that you're appealing against. It can't be a mystery until you get to the tribunal, because that would not allow them a fair amount of time and warning to prepare their case, to provide, reasons for what they've done. And the statement of grounds must be served on everyone through those processes, and it has to be within 14 days of the appeal being lodged. There must be enough specificity in the grounds to understand what it means. You can't just say, I don't like it. It has to be something like, it's going to be overshadowing, or I think the air conditioning plant is ugly sitting up there on top of the building and it should be moved, or whatever the reasons might be, so that they can actually determine, and it gives the tribunal something to decide about as well, specifically to try and deal with that. And if not, then there are processes to actually find out what someone wants, or indeed to dismiss that. Yep. It's the requirement of the applicant to prepare the applicant for review, the person appealing. It's their responsibility to have a statement of grounds. They might ask their planning consultant or their lawyer or their mate who happens to be a town planner to do it, but it is their job to do so. And in the standard forms, there are hints about what they're looking for. But usually by the time people get here, they're paying attention. They've got a reason for it. And then council then, and really we're talking about the responsible authority at this time, once they hear that there is an appeal by anyone else, they then have to send around all of the background information. And so basically that means, that council's got this extra responsibility on them to send all this stuff around once it kicks into this particular process. So as I said, in VCAT, we have this set of instructions called practice notes. And what this means, it tells you how to conduct yourself by serving documents, what information is required. Some of these practice notes even tell you what to do in the tribunal and what different roles mean in the tribunal as well. If you're an expert witness or you're acting on behalf of counsel or etc. They set out all these detailed procedures. And one of the big things that often happens in the larger cases is that people might decide to have expert evidence, whether they're for or against a particular proposal. So this is the chance of people appearing in the tribunal to say, oh, I really need an engineering expert or a heritage expert or whoever it is. But if we call them an expert witness, the practice note sets out particular characteristics that they must have and that they can be cross-examined. So you can see there some important values and important assumptions as an expert witness, that their duty is to the tribunal, not to whoever paid them. This is something that many people forget about or ignore or try to twist, but the tribunal is becomes very reluctant to take on the advice of someone who is clearly just pushing a particular view. And normally speaking, experts are people who are already known in the planning system in some way. Even if it's their first time appearing in the tribunal, it's fairly normal that we've already heard of them, you know, as in someone who's experienced and has worked a lot in this planning system. And so they're not meant to advocate on behalf of anyone, but advocate towards a professional and considered opinion of whether or not things are acceptable or appropriate or should be changed. And they have to include a number of things set out in the practice note, but also this very important statement: I have made all the inquiries I believe are desirable and appropriate, and that no matters of significance, which I regard as relevant, have to my knowledge been withheld from the tribunal. This is a fairly high standard. I would not recommend going as an expert witness without knowing thoroughly everything about the case. And in fact, being extremely careful not to withhold something because it's in your client's favour that might come out later. Because you're the planning expert for this case, and you withheld that the back part of the site is within a land subject to inundation overlay. No one noticed. Surely you would have worked that out if you're acting on behalf of them and told us right at the start of the 10-day tribunal rather than now. You know, so you've got to be super careful, check everything twice, know what everything means in great detail, because you will be cross-examined and any deficiencies there will come out very quickly. Another step in the process that is possible is the substitution of plans. And if this is for the permit applicant to do, and there's a practice note issued for that. And what it means is that if you discover errors or ways that you might want to improve the proposal, you have the ability to do that up until 30 days, business days, before the hearing. That 30 days is to allow the other parties to consider it and work out the implications of it, but also their experts might have to look at those and work out what they mean as well. So, you know, these are fairly onerous requirements, but they have a lot of implications. And if you do decide to substitute plans, you've got to give the actual notice document, you've got to fulfil all these requirements and to actually make sure everyone has ability to understand them and time to do so. So, the hearing, there's usually a set order of presentation unless the tribunal feels it's necessary to change these around. So normally we have counsel going first, the responsible authority. They set out all the facts. These are the things that happened. The land is zoned this, it's got these overlays. Notice was served on, a notification period occurred because we believe there's material detriment. You know, all of that stuff goes out. The referral authorities get to make a statement about what their position is. The objectors get to have their say. Anyone else who comes along and has an opinion. Then the applicant effectively goes last, where he or she and their team has the ability to respond to all of those previous parties, but in the interests of fairness that the tribunal is based on, you can also ask at the very end, even, you might be the council and something came up that the permit applicant said, you can still ask to make a brief right of reply at the end. You can see that this can potentially take a long time, and particularly on complex cases, this is why they might go into 10 or 20 working days sometimes, because everyone gets the chance to go through everything. However, I'd also add that the tribunal, if they feel it's going on a bit, will hurry things up to try and save everyone's time. So, council's got this underlying information to put out, but generally speaking, the proponent has the ability to actually make their case. And thinking back to the purposes of the Act, there is a predilection towards favouring development in this system. That doesn't mean anything goes, but we're trying to favour solutions in this system. So I won't go through all of this. It's probably there best for reading when you're studying for the exam and those sorts of things. But council's not really arguing its position, more it's giving out all of the facts and all of the facts that would support their original decision if they were able to make one. If it was failure to determine, they probably wouldn't do that. I'm really just reiterating here, and the proponent makes their case. So, the hearing in the tribunal does not have rules of evidence like it does in a court of law. So there's not swearing on the book of your choice or whatever, but rather it follows these rules of natural justice. It can seek out, sort of responding to a comment before, information as it sees fit and direct what happens in the proceedings to try and achieve that. And it can take into account pretty much anything to try and understand what's going on. But they might take things in and look at them. That doesn't necessarily mean they're going to give them all the same weight. Or they might even sometimes exclude things that they don't really think are very important. And natural justice is the driver. But as I mentioned before, the expert coming in has a very particular role and has to actually justify their position. So if you're an ordinary citizen and maybe you're an objector, you make your case, but no one will cross-examine you. No barrister will cross-examine you. But if you're an expert, you can expect, it's highly likely that you will be cross-examined by any party who can effectively do that, and they will ask you tough questions. Sometimes there are rules of evidence, but generally not. And it's about the expert witness demonstrating his or her credibility through these processes. So we go through all those things, and hopefully all of that information comes forward in such a way that the tribunal has the information it needs to make a decision, and irrespective of which way they go, there will usually be a discussion of what the permit conditions might be if they were to issue a permit. So this is quite a negotiated part, but it still reserves its decision. And then what will often happen at the end, they'll decide to make a decision on the spot or they might reserve that for 1 month, 2 months afterwards. They might want to go and see the site. They might want to make further investigations. They might want to look at some case law, etc. Then they publish their decision, and it has an order associated with that decision, and that's what the tribunal determinations look like. So there are no costs. Each party bears their own costs. So if I decide to engage a lawyer or an expert witness for me, I pay that out of my own pocket. And this is the final slide, I believe. There's also a major cases list where large projects can be put on a special list where they can potentially be processed more quickly. And they can pay a fee for that as well. So consider whether or not you think that's fair. That was a lot to cover and pretty dry, I'm sorry, but really important basic information. We'll spice it up a little bit in next week's. So, to give you time to get over there, I'll close it down now. Thanks very much, guys. Well done.